The Convention relating to the status of stateless persons is a 1954 United Nations multilateral treaty that aims to protect stateless individuals. Surrounding events: the United Nations Charter and Universal Declaration of Human Rights were approved on 10 December 1948. Of significance, the Declaration at Article 15 affirms that everyone has the right to a nationality. No one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. The Convention relating to the status of refugees was promulgated on 28 July 1951. Despite an original intention, it did not include any content about the status of stateless persons, and there was no protocol regarding measures to effect the reduction of statelessness. On 26 April 1954, ECOSOC adopted a resolution to convene a conference of plenipotentiaries to regulate and improve the status of stateless persons by an international agreement. The ensuing conference adopted the convention on 28 September 1954. The convention entered into force on 6 June 1960. Key substantive content of convention: the convention applies to stateless persons under the protection of the UNHCR but not to those under the protection of other UN agencies. It does not apply to persons with rights and obligations acknowledged by the country of residence as indistinguishable from those attached to the possession of that country's nationality. It does not apply to war criminals or to the perpetrators of crimes against humanity or against peace. It does not apply to those who have demonstrated themselves to have been enemies of international peace and cooperation. Contracting states shall accord to stateless persons the same treatment as is accorded to aliens generally. No exceptional measures to be taken against stateless persons in a contracting state because of the former nationality. Provisional measures affecting stateless persons may be taken in time of war or grave emergency where national security is at issue. Forcible removal of a stateless person from territory of a contracting state due to Second World War to count as residence in that territory. Personal status of a stateless person to be governed by the law of his/her domicile ahead of the law of his/her residence. Rights to property to be no less than accorded to aliens generally. Intellectual property rights to be no less than accorded by a contracting state to its own nationals. Right of association to be no less than accorded by each contracting state to aliens generally. Stateless persons not to be discriminated against in providing security for costs and eventual penalty, or otherwise by courts in contracting states. Stateless persons to be treated at least as favorably as aliens generally with regard to participation in wage-earning employment. Stateless persons to be treated no less favorably than nationals with respect to rationing, housing, public education, and public relief. Extension of Articles 20 to 23 to labor legislation and Social Security. Upon request, contracting states shall issue travel and identity documents to stateless persons within the territory. No discrimination against stateless persons in fiscal charges. Stateless persons to be permitted to transfer their assets to the place of the resettlement. Stateless persons not to be expelled except on grounds of national security or public order. Interpretation disputes between state parties to be finally referable to the International Court of Justice. Remaining clauses: territorial application, federal clause, signature, ratification and entry into force. State parties. As of the end of May 2016, the United Nations, the depository of the Convention, lists 88 parties to the Convention. 2 states have signed the Convention, but have not ratified it. The 86 parties are Albania, Algeria, Antigua and Barbuda, Argentina, Armenia, Australia, Austria, Azerbaijan, Barbados, Belgique, Belize, Benin, Bolivia, Bosnia and Herzegovina, Botswana, Brazil, Bulgaria, Burkina Faso, Chad, Costa Rica, Côte d'Ivoire, Croatia, Czech Republic, Denmark, Ecuador, El Salvador, Fiji, Finland, France, Gambia, Georgia, Germany, Greece, Guatemala, Guinea, Honduras, Hungary, Ireland, Israel, Italy, Kiribati, Latvia, Lesotho, Liberia, Libya, Liechtenstein, Lithuania, Luxembourg, the Macedonia, Malawi, Mali, Mexico, Montenegro, Mozambique, Netherlands, Nicaragua, Niger, Nigeria, Norway, Panama, Paraguay, Peru, Philippines, Portugal, South Korea, Moldova, Romania, Rwanda, Senegal, Serbia, Sierra Leone, Slovakia, Slovenia, Spain, St. Vincent and the Grenadines, Swaziland, Sweden, Switzerland, Turkey, Trinidad and Tobago, Tunisia, Turkmenistan, Uganda, Ukraine, United Kingdom, Uruguay, Zambia and Zimbabwe. Madagascar denounced its accession made in 1962, effective the 2nd of April 1966. The United Kingdom extended the convention to British Hong Kong, and China has declared that the convention continues to apply to Hong Kong post-1997.